Now, the essential problem in a deportation case and what lies beneath the surface is that the only way one can get out of it is either to ask permission to leave this country voluntarily and get out, which John was not prepared to do, or to apply for permanent residence status. And the law prescribes that any person who had ever been convicted of any offense, no matter how small, relating to the possession of marijuana at any time in his lifetime and under any circumstances cannot obtain residence. And so that what was happening when the government did this little routine of revoking his stay and charging him with being an overstay, they were locking him actually into a position where the only application he could make was one which they were pretty sure he could never succeed in.
Which was?
Pardon?
The application that he would make would be one that he would never succeed in, permanent residence.
Yes.
All right.
Now, we applied for permanent residence for John and for Yoko. We won Yoko's case, and she was granted residence, but John's case was denied. We went up on appeal before the Board of Immigration Appeals, and we lost there as well. And we are now before the United States Circuit Court of Appeals on the same issue. And basically, on that case, the issue resolves itself into whether or not what happened in England amounts to possession under our law, and whether what he possessed in England was actually marijuana under our law. You see, the substance which John was convicted of possessing, he pleaded guilty, was called cannabis resin. That's a generic term, and it includes a number of substances. We had one of the top experts in the United States, a psychiatrist at Harvard Medical School, testify, and he gave the only expert testimony. And his testimony was that cannabis resin is not marijuana, and marijuana is not cannabis resin. Yet the Immigration Service came to the conclusion that it was marijuana.